legal dictation at the speed of 100 words per minute. Get ready. Start. These appeals arise from a batch of interlocutory orders of the Allahabad High Court in a criminal writ petition 1786 of 2003. On 9 April 2003, a learned single judge of the High Court admitted a writ petition filed by the second and third respondents and stayed an order dated 7 December 2002 of the Additional Chief Judicial Magistrate Gautam Buddh Nagar, directing the registration of a case against them. The case was adjourned before the High Court on several dates on which it was listed. As a result of the adjournments, on the date of the institution of the special leave petitions, the writ petition was pending in the High Court for 6 years. This court was concerned with the pendency of similar cases before the High Courts where proceedings were stayed at the stage of the registration of an FIR, investigation, framing of charges, or during trial in exercise of the power conferred by Article 226 of the Constitution or Sections 397, 482 of Code of Criminal Procedure 1973. Hence, this court, by an order dated 8 January 2010, called for reports from the Registrars General of the High Courts in regard to serious cases involving murder, rape, kidnapping, and dacoity. On the basis of the data received, reports were presented on the court by the amicus curiae. These reports were considered in an order dated 1 February 2012 by a batch of 2 learned judges, including one of us, the learned Chief Justice of India. In the order of this court dated 1st February 2012, the findings in the second report submitted by the amicus curiae were summarized thus. As High Court, as 9% of the cases have completed more than 20 years since the date of stay order. Roughly 21% of the cases have completed more than 10 years. Average pendency per case counted from the date of stay order till July 26, 2010 works out to be around 7.4 years. Charge sheet was found to be the most prominent stage where the case were stayed, with almost 32% of the cases falling under this category. The next 2 prominent stages were found to be appearance and summons, with each comprising 19% of the total number of cases. During the course of the hearing of these proceedings, the Union government has been impleaded as a party to the proceedings, having regard to the fact that seminal issues are involved directly impacting upon the administration of justice. This court has assumed jurisdiction since the long delay in the disposal of cases, particularly criminal cases, has a serious impact both on the rule of law and on access to justice, which is a fundamental right guaranteed under Article 21 of the Constitution. In 1958, the 14th report of the Law Commission of India on the reform of judicial administration dealt with the issue of the delay and arrears and identified inadequate judge strength as the root cause of the problem. Stop.